hopefully to do so, could you give me an indication of the average time taken, and indeed what the longest time has been for a case to be resolved?
Well, I quite simply couldn't do that, but I know who could, and that's the Royal Sun Alliance as the lead insurers, because they are the claims handling body. But I can say, if I could perhaps define my terms slightly more accurately, undue delay on behalf of the lead insurers or their panel solicitors is what I'm saying doesn't particularly happen. Could I perhaps have a supplementary here as well? I maybe should have said when Mrs Macmillan asked me the question that we should not confuse the IPS payments which are made with claims under the master policy. The average payment, I think, over the last couple of years has been about £10 million. I mean, a significant amount of money is paid out, but these are figures that are assessed against the law of negligence.
I wonder if I could also, just as a supplementary, say briefly that the Law Society, of course, doesn't actually handle the negligence complaints that are made against the master policy. They go to the insurers, and the Law Society doesn't deal with those. So there's nothing that we can do at that end of things that can actually be overseen.
I understand that. I was just concerned that there was a very definitive statement made that has now been clarified. So there could be a delay, but it's maybe perhaps not an undue delay. Excellent, right. I like to understand things.
Before you press on, was this on this particular point?
Oh, that's a Swinney point, yes.
Exactly. Be brief,
yeah,
thank you.
I'm interested in what the President of the Law Society has just said about the fact that the Law Society has nothing to do with the arrangements for handling negligence claims, because I have in front of me a memorandum which was issued by Mr Mill in connection with the case of one of my constituents on the 5th of July 2001. And I don't know if it's available in the evidence base of the committee, but I know the convener has it already, and I'm happy to pass that on. Which
the committee has.
The committee has that. That's fine. Which, certainly, in the terms of Mr Mill's memo, it's a memo to the then President of the Law Society, Mr McAllister. It's also involves reference to the brokers of the master policy and the master policy that suggests that it would be good if we all got together, and I quote Mr Mill, and have a summit meeting to discuss how to dispose of my constituents' several valid claims. Now, I find that, and Mr Mill and I have discussed this at length over the years, but I do find that a rather strange memo to sit comfortably with the statement the President has just made.
Well, Mr Swinney, for reasons that are clear, I'll get Mr Mill to answer that, because that was before my time.
Yes, Mr Swinney and I have discussed this on several occasions over the last few years. I would actually say it goes a long way towards proving that we don't dabble in individual claims. I'll go on oath and on record and swear in my granny's grave that never once have I or any member of my staff, or indeed any office bearer, ever dabbled in a claim. What I am saying here is there are various parties. If you take Anne to be the Law Society, she in turn tenders the master policy brokerage on a 5-year rolling programme with Philip, who is the broker Marsh. He in turn buys it in the market from me, the RSA, as the lead insurers, and the other insurers each year, and when necessary they would instruct Caroline as the panel solicitors. Now, this is the sharp end of claims being dealt with. The layer of insulation between the Law Society and claims handling is Marsh the broker. And our President then, Martin McAllister, got a letter from Mr Swinney's constituent, and I think probably the committee will accept that many letters which our President gets are perhaps not with the same degree of foundation that Mr Mackenzie's issues have been. And I was asked to give a briefing, and I quite properly inquired of Marsh. I said I seek an assurance that these complaints, these claims are being progressed quickly, and that's what I get. I give my President an assurance that I'm satisfied, having been satisfied by Marsh, and this is all set out in the Marsh response which I refer the committee to. I have been satisfied by our brokers that our insurers and their solicitors are acting expediently here, and that message was relayed back. That's the sum and substance of it. If we did dabble in claims, it would be a very different memo.
I think for the sake of the record, I just would like to place on record the fact that the memo of the 5th of July encourages a summit meeting on the up-to-date position, looking at both the complaints and the claims aspects, which rather suggests to me that the Law Society have been involved in this area. And just also for the record, I would point out that this claim remains unresolved today, and this memo was dated the 5th of July 2001, and I appreciate your indulgence, Convener, to allow me to make that point.
Well, I really feel I really required to respond to two aspects of that. I mean, first of all, if the claim remains unresolved, that's really a matter for Mr Mackenzie and his agents and the master policy. There may be a plethora of reasons why it's unresolved. As far as complaints handling, Mr Mackenzie's inquiry of our then, I think, fairly recent President was the mixed issues, and we accept that from the client's point of view, sometimes they find it difficult to extract out what's a complaints issue and what's a claim issue. It is perfectly valid for me to inquire of Philip and his team, does Mr Mackenzie have complaints? Yes. Are they being dealt with expeditiously? That's very different from dabbling in the merits, which we would never do. I can give a personal assurance to the committee that that is and will always remain the case.
Obviously, this committee is not in a position to arbitrate in this matter, but we've got the matter on the record. Very briefly, if it is